Funding your trust sounds a little bit intimidating, right? It's really not that big of a deal. At its essence, when you create a trust, the trust can't control anything unless something is in the name of the trust, right? So if you create a trust on paper, you sign it, it's notarized, that's great. It can't control anything unless you put property into the name of the trust. So if you sign that trust and you leave your house in your personal name, that trust can't control the house. It's not in the name of the trust. Funding your trust just refers to transferring property from your personal name into the trust, either now or later. In general, there's two ways to get something into your trust once you have it signed. The first way is to transfer the asset into the name of the trust immediately. That's going to look usually like your name as trustee of your trust and the date that you signed the trust. It's kind of a long form title. The second way is to leave something in your personal name, but put a beneficiary on the account, and the beneficiary is the trust. So it's the trust name and the date that you sign it. There's not really a pro-con discussion in a lot of ways on these two things. It's really just do one of them. As long as you do one of them with everything you own, then the trust will control the property eventually. It's always best to transfer everything you can into the name of the trust immediately. In the case of real property, you own a home, an apartment, whatever it may be, even vacant land, you have to do a deed that transfers the title from your name into the name of the trust, and that gets filed at the county recorder. You must do that to make sure the property is governed by the trust document. For financial accounts, that's where it's a little bit more relaxed. If it's easy enough for you to take your certification of trust, that's a document that comes with the estate plan. If it's easy enough for you to take that into the bank or provide it to your financial advisor or jump online because you manage everything online, and update the account that you have in your personal name to be in the name of the trust, that's always preferred. That's great, because then you presently make it part of the trust. Don't have to worry about beneficiary designations. Not everyone is willing to do that, though, because a lot of banks, a lot of institutions will say, to have this be a trust account, you have to close your personal accounts, open a new trust account, transfer the funds over. And because that updates people's bill pay, direct deposit, etc., they're just not willing to do that. That's why you have the option of, for existing financial accounts, leaving the asset in your personal name, but having the trust be the beneficiary. And that's fine. You'll hear a lot of twisted advice around this where the trust makes, if it's a trust account, it's easier to deal with for incapacity over financial power of attorney. Usually that's nonsense. If you choose a disability panel in your trust, there's some argument there. It's a fair argument that if it's in the name of the trust, it's going to be easier to deal with. For most people's documents where a doctor's note is the trigger for incapacity, there's zero difference whether it's in their name or if it's in the trust name. The account is dealt with the same way. We just get a doctor's note to prove incapacity. So long story short, for current assets, they either become part of the trust by putting them in the name of the trust immediately, or the trust becomes the beneficiary and it will pay or transfer to the trust upon your passing. For future accounts, so once you have your trust in place, if you're going to purchase a new property, if you're going to open a new account, it makes sense to just open it in the name of the trust because you already have it. Why not? It's not more of a headache to open it in the name of the trust. One important thing, as long as your wishes in the trust document don't change, let's just say, like with me, our trust says equally to the 3 kids. As long as that wish doesn't change, we can sell our current house, buy a new house, open up a new trust account, whatever it may be, and we never have to go back and amend the trust document because the wishes haven't changed. So change of assets, as long as they're in the name of the trust, you don't have to go back to amend the trust document as long as your wishes haven't changed. So that's an important distinction there. Now, in addition to funding your trust, it's also really important to tell your successor trustee what you have and where to find it, so that if something happens to you, they know where to collect everything so that nothing goes to the state's unclaimed property or anything like that. That's where we'll use something like a Schedule A or any kind of financial ledger that just tells the trustee, I have these types of accounts at this institution, so please claim them. Doesn't mean that everything is necessarily going to funnel through your trust. Retirement accounts are one thing that may not, but it's important to list all of the accounts somewhere. Even if the beneficiary on the account is not the trust, it's someone else, That ledger is just a way to tell someone what you have, where to find it, so that it doesn't go, lost or unclaimed should something happen to you. Now, quickly on retirement accounts are kind of one little nuanced type of asset that may not funnel through your trust. Everything else, good to go, free to funnel that through your trust, whether that's a home, a bank account, investment account, a life insurance proceed, mineral rights, business interests, all of that can be in the name of the trust, or the trust can be the beneficiary or assignee. That's all fine. Retirement plans can be named to pay to a trust, but it's not always advisable. If you have minor children, the trust should be the beneficiary of your retirement plan, usually spouse first if you're married, and then the trust. But once you have adult children, it makes sense for your trust to not come into play on retirement accounts. So once you have adult children, we usually say have your spouse be the first beneficiary if you have a spouse, and then your children directly. So in whatever percentages you designate. That has to do with the Secures Act that was passed in 2019 and how retirement plans are dealt with. You can have a trust inherit the account. We have all of the language needed in all documents we use, either in estate lock or through our law firm, obviously. But once you have adult children, it's just more headache than it's worth to have the retirement account pay to the trust. So that's the one little quirky nuance there. Now, this obviously is just kind of a primer on the topic of funding the trust. Really, my point with this module is just to make sure that you're abundantly aware once you sign your trust, you're not done. You have to fund the trust with all of the assets that you want to be controlled by the trust. If you use an attorney to set up your plan, this is something that's going to be covered in detail, or should be at least, after you've signed your documents. And if you use the estate lock software, there's an entire module built out in detail of all the different common types of assets, how to get them into your trust, so that you're not just kind of blowing in the wind on what do I do? You'll be walked through exactly what you need to do, asset by asset, to get everything into the name of the trust. And with that, we'll move over to one of our final modules, updating your plan. When do you need to update your plan? What's kind of the trigger? What should you be on the lookout for to keep everything up to date?